Switch. You're live.
Thank you. Welcome, everybody. Welcome back. The House Committee on General and Housing. Today is still April 9th, 2025, and we are having an introduction and walkthrough and a little committee discussion, but not yet testimony about Proposition 3, Declaration of Rights to Collectively Bargain. I guess is Senator Hashim is not here. So we're going to proceed directly to Sophie.
Good morning, Sophie Zadatny for the Office of Legislative Counsel. As we noted before, there isn't really a good clean copy of the proposed amendment available, so I put together a PowerPoint that simply has the constitutional amendment on it, but just to make it a little easier for folks. I know that you recently had the clerk of the House in to talk about the procedure for a constitutional amendment. So just as a very, very quick recap, we're in the second biennium. It's passed through the Senate. It's with the House. As the Committee of Jurisdiction, you now have the constitutional amendment in front of you. You can't change the language to it. The language is set. I believe the committee is looking to schedule a public hearing on the proposed amendment. Once it is voted, assuming it passes and it's voted out of the House, the next step is that it goes to the voters of the state in the general election in November of 26. So just as a quick recap on where we are, yes.
And this year, last year, last biennium, we had to have a bigger number of votes in favor of it than we did this year.
Yes. But
It was 2/3 last year. No, was it 2/3 in the Senate last year?
it had to be a quorum. It had to have a majority of the members of the House. And this time it's as long as you have a quorum on the House floor, it's a majority of the quorum. So it is a
Right.
lower threshold than it was last year.
Just pointing that out.
Yeah.
That's
Go
important.
ahead, Ashley.
Just for the committee, to pencil in, we have, Magali has scheduled our hearing for the 22nd of April,
At 1 o'clock?
1 o'clock.
At 1 o'clock in room 10.
Oh, that's nice during the day. And then there's the written comments option.
And written comments. So for those who are here or listening, there is a deadline in the notice for, what's the date for deadline of submission of?
Sunday, preceding Tuesday of the hearing at 5 p.m.
So did you hear that? Sunday preceding the hearing at 5 p.m. People who want to testify at the hearing, we will take testimony, but separately, but if you want to testify at the hearing. And if you're listening online, you should contact our committee assistant and let her know that you want to testify. We'll set time limits in the hearing if appropriate, depending on the number of people.
They are 3 minutes.
3 minutes?
Mhm.
Okay. Please proceed, Sophie.
All right. Wait, no, it doesn't want to move. So all that, I was so excited to have it up and everything. Hold on.
I'll fill some space.
There we go. I just had one little thing I needed to clear out of the way. Okay, so section 1 of the constitutional amendment states that the proposal would amend the Constitution to provide that the citizens of the state have a right to collectively bargain. By past practice, just to be clear, this language would not appear on the ballot. So this is in the proposed amendment, but this is not language that appears on the ballot. And I stress that because there have been questions in the past around undocumented workers in the state and whether they would have the right to collectively bargain. And so this language about citizens is not something that would be on the ballot. So there's really 2 big sentences in this constitutional amendment. So they're together. I've just separated them into 2 sentences on the slides. So the first one is that employees, and again, employees, it's general, it doesn't limit it to certain employees or whatever, it's just employees. have a right to organize or join a labor organization for the purpose of collectively bargaining with their employer through an exclusive representative of their choosing for the purpose of negotiating wages, hours, and working conditions, and to protect their economic welfare and safety in the workplace. Right, so we already know we've gone through before with the committee. We had a background on the Labor Relations Acts in the state, and we talked at that time about the National Labor Relations Act, which covers most in private employers, and this really is filling the. So most people that work for a private employer are going to be covered by the National Labor Relations Act, unless they're explicitly excluded, which the specific exclusions are domestic workers, agricultural workers, independent contractors, and then public sector employees. So essentially, this language is really who's going to be able to take advantage of this is really the folks that currently aren't covered by some other labor relations statute. So for primarily, this is really going to be, public sector employees that are not covered or explicitly excluded right now from bargaining. Agricultural workers, for example, domestic workers. Vermont changed their law last year. So under the State Labor Relations Act, domestic workers, if they work for an employer that's got 5 or more employees, are able to organize and collectively bargain under the State Labor Relations Act. But so this is expansive. This is going beyond the folks that currently have the right to organize, whether under federal law or under state law. Working conditions. So right now, under Vermont, and I'm primarily going to talk about the State Employees Labor Relations Act because that's kind of the big player for public sector employees in the state. When it talks about for the purpose of negotiating wages, hours, and working conditions, and to protect their economic welfare and safety in the workplace, SELRA, the State Employee Labor Relations Act, has a very broad list of things that are your required mandatory subjects for bargaining. Again, we touched on this when we went through the overview of our labor relations acts before. So this doesn't, I wouldn't say this really, the wages, hours, and working conditions historically has been construed very broadly in Vermont. So I don't know that this goes further than that. Economic welfare is language that was in the recent Illinois constitutional amendment. It's not defined. It's not a term that we've used in Vermont or the Vermont Labor Relations Act has used. So I'm not entirely sure if you ask me what economic welfare means. I don't know beyond the wages, hours, and working conditions what that would be. Safety is something that traditionally is usually part of, contracts. When you're negotiating a contract, typically safety is part of that. So just to mention that there are several states that have constitutional provisions around the right to organize and to collectively bargain. The most sort of pertinent one for purposes of Vermont's proposed amendment is in Illinois. Illinois went through their constitutional amendment process, went to the voters in November of 22. And their constitutional amendment is very similar, not identical, but very similar, particularly in the breadth of the amendment. Their amendment is very similar to what's being proposed here. There have been efforts in California and Pennsylvania to propose something similar to what we've got as a constitutional amendment here. Those have not progressed. They've kind of stalled as far as I'm aware right now. But Illinois is the one that's most similar to this, but it only passed with the voters in all of November of 22. So it's not as if there's a lot of things that Vermont can look at to say, well, how is this going to play out? Essentially, we really don't know at this point. And then the second sentence of the proposed amendment. Therefore, no law shall be adopted that interferes with, negates, or diminishes the right of employees to collectively bargain with respect to wages, hours, and other terms and conditions of employment and workplace safety, or that prohibits the application or execution of an agreement between an employer and a labor organization representing the employer's employees that requires membership in the labor organization as a condition of employment. There's a lot of stuff in that. So the no law shall be adopted that interferes with, negates, or diminishes. Again, I was not here when this was initially being proposed, but I would anticipate one of the driving motivations was to make sure that Vermont does not adopt a right to work law. So there are a number of, probably over half the states, I think it's around 27, 28 states in the country have right to work laws. Those are laws that mean that you cannot be required to join the union. And so this is essentially saying that no law would be adopted that would interfere with the rights that employees currently have under Vermont law. So just something to be aware of on that. I think there's one other thing. I believe that was the intent here. But something as legislators, I think, to be aware of is that no law shall be adopted that interferes with, negates, or diminishes. That means that moving forward, the legislature also can't adopt other laws that would limit bargaining rights. So, for example, a couple of years ago, the legislature passed a law to say that moving forward, that under the Labor Relations for Teachers and Administrators Act, that there would no longer be negotiations at the local level over healthcare. That's now negotiated on a statewide level. So arguably, this may tie the hands of future legislatures in terms of saying, you can't bargain over this in the future, or you can't do that. So just something to be aware of. This is very broad. It's not limited to not adopting a right to work law. But
it's prospective.
this is prospective, so no law shall be adopted. So any existing law, is the law right now. But yeah, this would say that you can't adopt something in the future that would change.
But just a question about that. You go back, wouldn't the first, let's take it, for example. We've seen one of the bills before us is a bill that would allow someone who, I can't remember, I think it's either assistant attorneys general, or it's the one that involves, I can't remember, some other employee group, I should remember.
Judiciary supervisors.
Yeah, perhaps.
Yeah.
So there's a section of the law right now, which I guess would be in SELRA, that says it's up to the board. The board makes the decision on whether to certify a group to be able to organize.
Yeah, so that would.
And those were written as provided, however, and then they said that the group that's the target of the legislation can. In other words, they took away from the board, these proposed bills take away from the board their ability to decide. But as I understand it right now, the board makes the decision, right?
Well, it's in statute. So the judiciary supervisors would be under the Judicial Employee Labor Relations Act. So right now, judiciary supervisors are one of the groups that can't organize and collectively bargain. So that provision would remove that exclusion. And then similarly, under the State Employee Labor Relations Act, there's a long list of folks that are not considered employees for purposes of the State Employees Labor Relations Act.
Right. Well, I guess my question is, although these laws are existing, wouldn't they be invalid under Section 1?
Yeah, arguably, yes. This would certainly mean that it says employees have a right. It doesn't limit it to only employees that are currently allowed to bargain. So I think it says employees. And once this is in the Constitution, then you have a constitutional right to organize. That's going to trump a statutory prohibition on organizing.
So it's Article Section 1 is self-execute.
It's going to depend on what a court decides. So there have been different decisions on that. So New Jersey has a constitutional right to organize. New Jersey didn't pass any specific labor relations laws relating to agricultural workers, and agricultural workers organized. And the argument was, well, you can't because there's no statutes of allowing you to do it. And the New Jersey Supreme Court held, well, it's a self-effectuating statute, so they have the right to organize. New York did the same thing with agricultural workers. What happened in New York was I think it was a lower court and appellate court said that they had a constitutional right to organize. And then the legislature immediately passed a Labor Relations Act that covers agricultural workers.
Would we, for example, but am I right to assume that the broad constitutional amendment in section 1,
Not section 2.
no. It's section 2, right?
Yeah, okay.
Section 2. So wait, let's go back. So what you're saying is section 2 is kind of freestanding, says you have this right. It's self-executing, so if there was a state law of any sort that contradicted it, it could be invalid, or one could go ahead and organize. Section 3 is prospective and says,
These are both, sorry, it's confusing, but there are 2 sentences, so they're both in section 2.
oh,
I
okay.
just want to be clear, right? But you mean the second sentence, the second part of section 2?
No, wait a minute. The one that says employees may organize.
Right, that's the first bit, yeah.
Okay, right, yes. So you're saying that's sort of self-executing in the sense that a law which interfered with somebody's right, current law, would be invalid. And the second sentence would make any prospective law, particularly a right to work one.
Right, that you can't adopt any laws in the future that are going to interfere with, negate, or diminish the right of employees to collectively bargain.
So what about laws that are laws that propose to establish procedures for the first sentence? In other words, I mean, I'm really pretty ignorant here, but as I understand it, typically labor laws provide that if you want to organize, a certain percentage of the workers have to agree to a union.
Right,
Well, so there's nothing like that in the first sentence. So if we were to pass a law that says it takes 30% of the workers, would that violate that section? It can't be self-executing, can it, if there's no procedure?
so I think what would happen is the existing statutes that we have, for example, around 30% interest in order to hold an election, or 50% plus 1 for card check. Ultimately, that would come down to, again, someone would have to make an argument that those statutes are interfering with someone's constitutional rights under what's being proposed here. And then a court would need to look at that and decide whether or not, that's a violation of the constitutional right. And then typically courts that have been looking at the right to organize and collectively bargain have been applying a strict scrutiny test on the right to organize and collectively bargain. I don't know, for a procedural thing, that may not be a fundamental right to a 30% showing of interest or something, right? That may be a different standard. But generally speaking, if you have a constitutional right to organize and collectively bargain, and there are limits on that, then the court's going to look to see whether or not, under the strict scrutiny standard, whether or not that's an appropriate restriction on that constitutional right. So it's not that you couldn't have restrictions on it, it's just they're going to have to meet that much higher threshold.
Are there definitions under state law for what an employee is?
Yeah, and under the current statutes.
Under the current
And their employees defined somewhat, all these different employment laws, right? So, we looked at the Parental and Family Leave Act. There's a definition of what an employee is under that. But certainly under the Labor Relations Acts, there are definitions of, who's an employee for purposes of collective bargaining, and then who isn't. That's where the exclusions come from.
Would those laws survive? Is that the first sentence of this?
The first sentence. Yeah, this is really, I think, is expanding the right to organize or join a labor organization to folks that are not currently eligible to organize or join a labor organization. So this is just expanding who can seek to organize.
Go ahead.
I'm at this point a little confused.
Yeah.
Can I just say something out loud and you just tell me if I'm off base? So we have the 50% plus 1 for
Card check, yeah.
card check. That's still fine. All this is doing is saying we are not putting any restrictions on who can unionize. There are still thresholds that a union would have to meet in order to unionize, correct?
Yeah, I don't, to be honest, I don't know exactly how it, I mean, so right now that we have 7 labor relations statutes, I would imagine courts would look to those. I mean, and a lot of them, there are the quirky differences between them, but they sort of like majority sign up, right? That's 50% plus one, you know, it applies sort of across the board. So I think those would still apply, but if you had a brand new group that doesn't fall into one of the existing labor relations acts, I'm not entirely sure how that plays out. And again, I don't know if this was all discussed when this amendment came up last year, and maybe this was all fleshed out last year, and I'm just not aware of
At
it.
least not in this committee. Can I ask another question? Once again, just trying to like wrap my head around it. So right now, ag laborers do not have the right to unionize.
Right,
This would give that to them. And they do not, as of right now, they wouldn't fall into.
they don't fall into any of the existing buckets.
So you're saying that they wouldn't have to meet that threshold?
I don't know. I don't know how that would play out. I mean, I would assume that, again, I think if you've got procedural rules, those can be viewed and, you know, as on a more rational basis. I mean, there has to be some sort of organization and rules around how you do things. I think this first sentence is, as I understand it, is intentionally expanding to say that basically everybody has the right
Yes.
to organize or join a league. It's not saying how you do it, what the requirements are, you know, what the showing is. I mean, you'd still have to have some mechanism whereby you establish that, you know, a majority of people want to have a union or whatever. I mean, I would imagine you would go back to the sort of labor law principles on how you look at that.
Yes.
Yeah, so I think I recall dialogue about this, and if I recall correctly, agriculture workers are not considered employees, and we had, if I recall correctly, we've had conversation in that regard.
Ag laborers were just an example. 'Cause I
Okay.
knew like they were. the
Okay.
one
Yeah,
that
I'm
first person
like,
to have-
okay, I was like, wait a minute, 'cause
No,
I'm like, I think we had like a whole
I know about that, yeah,
definition
yeah.
of employees and what that would cover.
Yeah,
And so I think based off of our definition of employee, I think that is what would categorize. Because we have a specific definition of employees and what that means for certain businesses and the different categories. And so I don't think it's as general as we are perceiving it to be in this context. I think, if I'm not mistaken.
Well, agricultural workers are employees. They're just explicitly excluded from coverage under the National Labor Relations Act. And then in Vermont, they're excluded under the State Labor Relations Act.
Not excluded as employees, but excluded.
They're just as a category of employees, they're excluded. It's not that they're not employees. It's just that if you're employed in agriculture, you're excluded from being able to currently organize and collectively bargain under
You're
federal.
not excluded from the definition of
Right.
employee.
Right,
sorry, that might
you're
have
still an
been
employee,
a
right?
bad example. Could you give us a recommendation of who might be able to answer that question? Like, would maybe we bring somebody in from?
I think we have a lot of experts in the room that hopefully we'll hear from, because I'm just feel like this is going a little bit, I don't know. I think we need to have some people come in to talk about this.
Well, we
That's
will.
what I just said.
We will.
Like it was the same concerns. Oh, sorry, go for it.
And then, and then Joe, yeah,
Whether or not we have access to the testimony documents that were given to the Senate last year.
we do.
Okay,
In this-
can we find those online?
We have a
I'll-
list
I'll
of.
check that later.
Is that what-
I have to say, I mean, I think constitutional amendments are pretty powerful, and if there was a group of employees who wanted to organize and they were not permitted under state law to organize, I think they'd have a very strong case regardless of what state law said. Whether they were excluded as employees, the question would be, does the word employees in the Constitution, was it meant to be limited by all the existing statutes? And I don't know the answer to that.
In this section 1, if it's.
You mean section 1, the purpose, or just the first sentence?
Section 1, no, okay, it's actually, should we know that? No, maybe it's the next one. No law shall be adapted to interfere with the case or diminishes, so it does not change existing laws.
No.
And if existing laws specifically exclude or do not include, what does it change for them? Does it change?
Well, you'd have a
Instead of-
constitutional right, and your constitutional right's gonna trump the statute.
Okay, so what is the point of the sentence then?
This one, I believe the intent was to make sure that Vermont did not pass a law that would make the state, what's called a right to work state. Or, I mean, again, it could be
Well,
broader than that, or any
I
other
can
law
understand the
that
second
would.
half of this doing that. I'm just not sure how
We'll talk.
the first, it's all one sentence, isn't it?
So the second, I mean, we haven't really talked about the second part of the sentence, so, or that prohibits the application or execution of an agreement between an employer and a labor organization representing the
Yep.
employees. So that's what that's
Yeah.
saying, is you can't pass a law that would prohibit those agreements. So those are kind of union shop agreements, like if you're an
Got that, yep.
employee here.
Yep.
You know, it's a union
Which
shop,
is
like
the
you
union.
need to be a member of the union.
It's
And,
before the or.
okay,
And it's really just that first line, no law shall be adopted that interferes with, negates, or diminishes the right of employees to collectively bargain. That's going forward.
right.
So I'm not, do we have can we get an opinion from Superior Court? How does this even work?
I don't think it could.
Because rather than-
We could always,
I mean-
someone could always ask a court, but I don't think a court would rule on a law that doesn't exist yet. I mean, a constitutional.
Okay, but it just seems to, to put it into law and then see what they do with it.
There was testimony last session from Professor Teachout from the Vermont Law School. There may have been others, but I know he submitted
That
written
would be valuable.
testimony
Okay,
about
We have that.
about the proposed amendment.
His testimony in the Senate was different from his testimony in the House. I mean, in the House, it was in judiciary. And it was in Senate judiciary as well, but they were not. He didn't testify the same in both. Things.
I've just seen one set of testimony. I don't recall which one. I'm gonna have it here somewhere. I can look and see, but
I have his testimony, but I can't tell. It just doesn't say whether it was the House.
from Senate Economic.
Was that from Senate? Okay. Oh, we're right. For Senate Economic. Yeah.
Yeah, so I guess just to finish up the second part of this sentence, that wouldn't apply to public sector employees because there's been US Supreme Court decision in 2018 called the Janus decision, which means that you can't require public sector employees to belong to the union or to pay union dues or an agency fee. So that language would apply to private employees of private employers, but it wouldn't apply to public sector employees. And again, because that's a Supreme Court decision, that would trump the Vermont constitutional provision.
So the right to work.
just for public.
It's for public sector employees, the Janus decision.
So the right to work, it can't apply to public sector employees.
Right. Effectively, yeah.
So this would, but the way we have it worded, it does.
This would suggest that it would, you would be required to pay either your union dues or pay an agency fee. But that wouldn't work in practice because there's a US Supreme Court, and then until they reverse that or change their minds, which doesn't seem likely in the immediate future, that right now public sector employees cannot be required to either belong to the union or to pay what's called an agency fee. You can be covered by a union contract and choose not to be a union member, but then typically you pay an agency fee to cover the costs of the collective bargaining, the grievance process, and all that stuff.
Does this have any bearing on right to strike?
It does not mention right to strike. So it does not,
But it does, so it doesn't mention it or imply it. It's like collectively bargain with respect to
Right.
wages is not.
could someone make an
For
argument
other
at some
things.
point that the right to, you know,
It means collective bargaining.
yeah, I mean, that's a potential argument that could be made. But this doesn't specifically give somebody the right to strike. Someone, I mean, again, I assume, you know, there are creative lawyers, I'm sure someone could argue that there's a constitutional right. I mean, again, under federal labor law, the right to strike is considered a fundamental right. So whether or not that would then, someone could make an argument that, you know, although it does not explicit here that should encompass it, I mean, that is a possibility.
Yes. Go ahead.
I should know this. What happens if this constitutional amendment disagrees with the Supreme Court? Is there any issues with that? Or is it just like, oh yeah, it's in our constitution, but Supreme Court, so.
It's the US Supreme Court.
Yeah,
Yeah, the US Supreme Court's decision in Janus would trump the language in.
so it'd just be a matter of, it will just trump it and it is what it is, okay.
Just to clarify something you said earlier. The federal law addresses private sector employees. Does that mean we can't adopt provisions that affect private employees but are more protected?
It would be preempted, there would be arguments.
entire
for
area
preemption,
It's
right?
preempted, you're
Yeah, I think the National Labor Relations
by
Act.
NLRB.
And the NLRA is different to like the FLSA, the Fair Labor Standards Act. The NLRA does not establish a floor, it occupies the field. So if something were to conflict with the National Labor Relations Act, then the National Labor Relations Act would preempt the state law.
But there's nothing in this amendment, right, that would prohibit establishing wages, hours, and other terms in a normal contract negotiation, right? In other words, it doesn't guarantee anything other than the right to bargain.
Right, I will say Vermont has typically the mandatory subjects for bargaining in Vermont has always been very broad compared to other states.
Right.
So the breadth of that language, I think, is probably consistent with the way Vermont traditionally has viewed mandatory subjects for bargaining. There are explicit carve-outs, like, again, for teachers, we're discussing healthcare and others, but
But let me give an example. Somebody says, oh, what's wrong with this constitutional amendment is certain jobs require long hours. The answer to that is that's the subject of contract
Right, you would-
negotiation. That's not prohibited and or in any way affected by this, right?
right, you discuss those things at the bargaining table. This just gets people to the bargaining table to then talk about those things.
I do wonder, just as a comment, I do wonder about this sentence that's behind you. If you say, number one, it can apply to private employees because that's preempted by the NLRA. And it can't apply with respect to the second part of the sentence with respect to public employees because that's
That's
contradicting.
only one piece, though. That's
Okay.
just, so this has got two parts. I mean,
Yeah,
again,
okay,
it's a
yeah.
long sentence. It's got a
Yeah,
lot of
but
stuff
the first
going on
part
in
of
it.
the sentence stands.
Long
Okay, yeah.
Yes. I just did a CLE yesterday about, clear writing, short, clear sentences, one idea per sentence. And I would say this has got a lot of stuff in it, a lot going on. But again, you can't, the language is now set, so it can't be changed
Right, I know.
as a.
I have more question trying to understand it. Yeah, okay. Go ahead.
And I just want to clarify that this is the right to collectively bargain, which is separate from independent bargaining with individuals. So what this does is it allows employees the right to collectively bargain and unionize so that they can together collectively advocate for fair wages, workplace safety, and working conditions. So that's the differentiation is bringing folks to the table to be able to collectively bargain as opposed to an employee individually advocating and bargaining for their own
Right,
independent.
yeah.
But if you are covered by a union agreement, if the employer has a bargaining agreement with a union in their workplace, you as an individual employee cannot do that. You can't, it's called direct dealing. You can't have your own individual arrangement with the employer. You are covered by the union contract. Whether you're a member or not, you're covered by that contract. But if you're working for an employer where there is no union, then yes, you would, yeah, that would be it.
Elizabeth,
I just want to say that I misremembered about Peter Teachout's testimony. That was in regards to the other amendment, which is the one that has to do with 14th Amendment.
Okay.
questions, more questions. I guess I had one more, but I'm gonna wait whether others. I want to go back to what we were talking about earlier. The question is, who's an employee? And one of the things you said was for example, you used agricultural workers. They're not exempted from being an employee, they're exempted from the right to bargain. Is that correct?
Right. They're still employees, and even under the National Labor Relations Act, where they're not, they're explicitly excluded. I mean, again, this has come up a lot because of the Agricultural Workers Study Committee, where we were looking extensively on this. So this is why agricultural workers are kind of at top of mind. But there is, federal case law up at the Supreme Court regarding, undocumented employees working in agriculture under the National Labor Relations Act. And the court, I mean, again, recognized they're employees, but because they were undocumented, their remedies were limited under the National Labor Relations Act. So the fact that they're not covered by the National Labor Relations Act doesn't take away the fact they're still recognized as employees. It's not that they're not employees, they are.
Well, so is this similarly the case with, I'm just picking on the cases, the bills that are on our board. We have bills that say give the Assistant Attorney General, or no, it's not,
Yes.
it's AAGs,
Yeah.
the right to organize. Would that be preempted by this? Or are they arguably non-employees, or are they clearly employees who just are excluded currently?
So right now, there are employees that are explicitly excluded.
So those kinds of bills may be trumped by this amendment.
Right.
Not that we wouldn't pass it anyway, it would stand, but it wouldn't, but
Because this would not, I mean, just to finish up, but, if this passes through the House, then it goes to the voters. So this wouldn't become law until
Yeah,
November 6th.
but I mean, even if it would be harmless, but it wouldn't be, and if this became law, it would trump. It would essentially say,
So if you didn't pass for assistant attorney generals, for
Yeah.
example,
it would give it,
but then this was voted on and passed by the voters, then they would have the right.
they would have the right, yeah,
That's
okay.
Is there another group that is also excluded?
There are a lot of groups under the statute, under the different statutes, legislative staff are excluded. There's a lot of groups that are excluded from being able to.
Sorry, there are a lot of side conversations and I think we're all trying to listen and I'd appreciate if we can just listen to the testimony we're getting. Thank you.
So, thank you, agreed. So there's any number of excluded groups, and what you're saying is they're not excluded from the definition of employees, they're excluded from the right to bargain.
Right, under state law at the moment.
So you think it's possible that those groups would have the right to bargain under this amendment?
Yeah, I mean, again, there's no limiting language. It's employees have a right to organize or join a labor organization. And again, most employees are already covered, whether they're unionized or not, but they're covered either by the National Labor Relations Act or they're covered under one of the 7 Vermont Labor Relations Acts. there are specific folks that are not covered by those acts that are excluded. So presumably, this is giving them the constitutional right to organize and join a labor organization.
This is, I'm sure, a key factor, which I think we'll probably hear testimony on. Yes,
And I think this whole argument is basically gonna just boils down to how the Supreme Court would rule on it, right?
Well, for sure, there'll be litigation around the parameters of it. I mean, I will say that, again, something very similar passed in Illinois. And I've not been able to, I mean, court cases just take a really long time, and particularly before decisions are published. I haven't been able to find any cases that have kind of gone the whole way through, whether there are cases that are currently, challenging how it's being interpreted, or employees seeking to organize, being denied the right and are claiming a constitutional right. The only one I'm aware of in Illinois involving employees claiming to have a constitutional right to organize is actually legislative staff in Illinois. And that case was filed in beginning of June of 2024, and it's still pending. So I don't know. And it's a different, they have a different structure than legislative staff do here. So again, the outcome could be on procedural grounds there. It's hard to read the tea leaves on it. But so the bottom line is there isn't any law out there really to go look at to say, well, how is this going to be interpreted? And even if there is, again, if you're looking at public sector state employees, there are so many different structures for that state by state that even when Illinois does rule on something, I don't know how persuasive it would be here unless it was more general principles. But ultimately it would be up to the courts to determine this constitutional right and to give it shape and, when it applies, when it doesn't.
And section one's our intent. Does our intent show any intent to allow us to carve people out that aren't allowed to?
I mean, again, it's very broad. It provides the citizens of the state with the right to collectively bargain. It's not limited in any way. And I only flagged because we had the whole citizen issue came up as part of the agricultural workers study. But again, this language wouldn't be on the ballot, but that's
Well, it's what the Supreme Court would look at.
Right.
They'd say what they intend to do, and then here's our purpose.
Right.
We clearly don't intend to.
To exclude anybody based on this, right?
questions? Well, thank you very much.
Is Senator
Hashim,
Hashim coming or?
None of the three senators, not Senator Clarkson, Senator Raffensdale, or Senator were available or indicated that they would like to come.
I see.
so we've had the introduction. I think
No, we
that,
had a walkthrough.
and a walkthrough.
No.
We didn't have the introduction. Did they say they just weren't interested in, or they weren't available?
Senator Hashim said that he thought someone from Senate Economic Development would be better suited because they had done the bulk of the testimony and also was unavailable. And both Senator Clarkson and Senator Hinsdale said that Senator Hashim should testify instead.
Okay, so we'll see if we can clarify that. Good, great. Right. Any other final questions of Sophie before we move on? All right,
What was it?
Good job.
our next item is at 11, and I do not see the author. It's just an introduction, and we're going to have a series of introductions. I don't see the author yet, so we'll take